Thank you.
Just for our other members, one thing we'll have to keep in mind, since anytime we do a teleconference, and for our new members, we have to do a roll call vote. So what that means is that afterwards we'll go down the roll, and then you can enter in your vote. Then yay or yes or no will suffice, and then we'll tally the votes at the end. Okay. All right. We'll jump on in then. This is the regular scheduled meeting of the Court Reporter Board. Notice of September 27, 2019 meeting of the Court Reporters Board was posted to the Court Reporters Board website August 29, 2019. If we will, then we'll call this to order. We don't have a chair at this current venture. We're going to have our election of officers next meeting. The law does require that we vote in members each year. And so as a result, we'll do that at our next meeting. We do have a vice chair, Miss Morgan. We have, so she's en route. So I'll just facilitate until she gets here. For roll call, let me go down the roll. Just let me know if you're present. Okay. Let me get to mine. Britton Collins. Looks like he's absent. Judge Rambo.
Present.
Oh, great. Marilyn Morgan. She's en route. Mr. Mansfeld.
Present.
Mr. Pettis.
Present.
Miss Neal.
Present.
Miss Branham.
Present.
We do have quorum. I've already read the notice of meeting. We'll dive right into the agenda then. You have the agenda, should be sitting there in front of you. Are there any amendments, any edits that you would like to add? If there are, please do so now in the form of a motion. If not, if someone could enter a motion to accept it as printed, that would be great.
This is Judge Rambo. I move that we accept the agenda.
All right, thank you, Judge Rambo. We have a motion to accept. Do we have a second?
Second.
We have a second from Mr. Mansfield. Now for roll call vote then to accept the agenda as written. Mr. Pettis?
Yes.
Mr. Mansfield?
Yes.
Miss Neal?
Yes.
Miss Branham?
Yes.
Judge Rambo?
Yes.
Thank you very much. That's been approved and accepted. We'll move on to the next item, the March minutes. Although some of our members weren't here for that meeting, I trust they had an opportunity to read those. Of course, the video is also on the website as well. Does anyone have any comments as to those minutes or questions, edits, revisions, anything of the like? If not, we'll entertain a motion to accept them as written. Do we have such a motion?
I make such a motion.
We have a motion from Mr. Mansfield to accept the March minutes. Do we have a second?
Second.
Judge Rambo seconds the motion.
Looks like we'll have a second as well from Mr. Pettis. For roll call vote, Judge Rambo?
Yes.
Mr. Pettis?
Yes.
Mr. Mansfield?
Yes.
Miss Neal?
Yes.
And Miss Branham?
Yes.
And Miss Neal, you can also use the other mic there if that's helpful. We can bring that down to you. And as far as the iPads go for our new members, if you touch near the top, it'll give you a menu, and then you can select each of the documents that we'll be discussing. All right, great. We'll move on into to the budget, to the director's report. I will give if you would, just sort of entertain a little bit extra time on this. I just, for the sake of our new members, want to go through some of this a little bit. We won't go deep dive until the next meeting. Once we have the end of year fiscal report, we'll give you sort of a bigger picture of total reserves in comparison to the trend analysis. What you're looking at right now is the trend analysis. Okay, that's just basically month to month inside this fiscal year. Below that, you do have a little bit of a snapshot of the reserve balance. You will one thing that's typical with the court reporters, I'll just start to say, is that, as you know, you have a biennial renewal period, which means every 2 years everyone renews together. That was done last June, July period. So Typically, we'll have a big surplus in revenue as a result of that renewal, and then we kind of trail off for 2 years, pretty much in the red, not far or deep into the red, but we pretty much track in the red until the next renewal period. All right, so that's not uncommon. Don't be scared by that red there. Land surveyors the same way too. They have a biennial renewal period as well, so it tracks very much the same. The very top is your licensing revenue, and then the columns or the rows below that are the court reporter's expenses, and then that red and green there is your surplus and deficit for each month, and then below that is your reserve balance as a result of that deficit or surplus. Okay, so it tracks the total health there. You'll notice there was a spike in revenue for June and July. If you look at the very top, well, you don't have June, but you have July there. Big spike in revenue. Now, if you look to the right, or to the right of that, in August, you've got a big, deficit for the revenue, a reduction of revenue there. That is a result of basically the revenue that was received in June was paid in July. Basically, the credit card statements for that renewal period had to be reallocated out of the August budget. So those credit card statements, it was reporting more revenue than was actually there. So that reallocation in August is why you have that big reduction of revenue in the licensing revenue portion. All right, so we won't see that again until next renewal period, this time next year. All right, let's see. Technology and other, if you'll see on there's a spike in expenses for October. That was due to increase in total administrative cost back for period 4 expenses of all the programs, largely due to vendor expenses due to system enhancements. Thank you, Ms. Morgan, for joining us. No worries. Traffic can be a beast. We all know that. So it's very unpredictable, ebbs and flows. So go and get settled in. We're just at the informational portion right now of the budget, so you haven't missed anything yet. All right. I'll kind of give you a snapshot of what you're looking at there. Let's just look at court reporters' revenues. You got licensing revenue. That's everything that comes in for applications, whether those be renewals or initials. That's the licensing revenue. Case revenue, that would be everything that is any judgments that are rendered as a result of the legal report, anything that we receive as far as disciplinary action, punitive-wise, would be assessed there. You'll see that that revenue show up there. State reg fee, there's nothing there. Some of the other boards, they'll have there's an administrative workaround where fiscal finance administration will print out licenses, and then they'll reduce our revenue there. So it's an accountant sort of workaround. We don't see that here. It's not necessarily, you won't see that line item. Expenses, Edison expenses, you're looking at basically payroll, technology, other type of expenses or things that just don't fit in Edison. If you're not familiar with Edison, that's our personnel and our finance clearinghouse. That's basically, those line items exist in there where we make payments out of those funds. If something doesn't have a nice, neat line item or doesn't fit in there, but would still qualify as administrative expenses, we get to see those administrative expenses. So it's not some sort of dark figure that just comes out of the other budget. It's not a miscellaneous budget. It's just where they don't have an allocation in Edison, then we pay that out of the other budget, and sometimes administrative expenses. But we get a detailed, itemized list of what those expenses are as well. So you're welcome to that information anytime you would like to see that. Administrative cost backs. That's basically the rent, phone lines, fax lines, and administrative support from IT. Some of that comes out of that budget, and that really comes out of the total program budget. Obviously, Court Reporters doesn't have their own building. They don't have their own. They have a phone line, but they typically share that with other boards as well because we're not a big board. So we have to proportion what the expense that needs to be allocated to the Court Reporter specifically. That's done by how many complaints, number of licensee pool, and program budget. So obviously your percentage is going to, and we'll go over some more of this at the next meeting, but your percentage will be much lower. It'll be a fraction of a percent. Whereas Cosmo and Barber, who has 60,000 licensees, they were like 16-17% of the total administrative cost backs, whereas Court Reporters will be a fraction of a percent. So you won't see a lot out there, and we just try to, those things that aren't specifically court reported, but court reporter shares in, your proportion would be that fraction of a percent that comes out of administrative cost backs. Centralized complaints, we have basically a call center that handles all incoming inquiries. You see, it's your share that's so low that it doesn't even register until March. Legal cost backs, that would be the legal report that you're about to see later on in our agenda. Into all of our attorneys that work on that, charge the program billable hours, and so that'll be registered there. Investigations, if we send a subject matter expert out to the field to investigate a particular complaint, that's where that would show up. As you can see, there's nothing allocated there. That's just not common. Typically, what we need, we can handle here in this forum. Field enforcement, that would be inspections. As you know, Cosmo and Barber would have a lot of that. Court reporters doesn't have anything in statute that requires inspections, so that's why there's nothing there. But you're kind of seeing the flow now about how all of that works. And then if you have any questions along the way, you, of course, feel free to reach out to me at any point, and I'll be happy to share more information, elaborate. But that's kind of the crux of it all. Are there any questions? If not, we don't have to vote. That's just for your information. We're in good financial stead. If you look at the end of June, our total reserve is $131,000. So we're doing fine. Our biggest expense was coming into our licensing system, and we're past that. We don't have anything on the horizon that we anticipate will be a problem for budget-wise or revenue-wise. All right. Okay, we'll move on to the next item. That would be rule amendments. This is where we'll spend some time, and I'll go ahead and cede the floor to Ms. Thomas.
Okay, just for our new members, so we are at the beginning of a rulemaking process. Our last meeting, we had some discussion about a couple of different amendments that the board would like for me to make. What I did was I put that in the rulemaking form, presented it to the board to kind of show them the red line of the changes, and if you all have any further edits to these particular chapters or anything else you want to add, this is the time to do it before we move on in the process. So I guess I'll ask first on Rule 0455-01-03-.02, Part 1. I'll ask if that's an accurate reflection of the changes that were suggested and if there was any additional change to that.
Looks just right to me.
And then for the record, the second change was 0455-01-04-.01, subpart 1, G. We changed, we took out the word shorthand and put untranscribed in describing the notes. I didn't know if there were any other changes to the standards of professional conduct that the board saw fit to be added at this time.
For the sake of our new members, Mr. Mansfield, would you mind maybe elaborating a little bit of how we got there, just kind of the crux of it? And you're looking at page 2 of the rule amendments on document number 4. That's where the changes are. Both changes that Ms. Thomas discussed are both articulated there. Just a high view. We don't have to deep dive, but just, yeah.
The first part was something I had brought up years ago, and I think Sheila Wilson had brought up too on behalf of the Tennessee Association, in that the disparity between passage of the RPR and the CVR and the CER. What we had at that time was the RPR is a knowledge test and also a skills test which requires producing a transcript. The CVR, to my understanding, is very similar to that, only it's for voice writing. Since Tennessee recognizes steno machine shorthand, voice writing, and also electronic recording, the thought was that it should be similar in its certification. The way the rules read initially was a certified electronic reporter was only a recorder. Had nothing to do with transcription whatsoever. And so there's another designation from the electronic transcribers, and that was the certified electronic transcriber. And so in order for it to be equivalent to the RPR or the CVR, it should be both. And so by adding the word "and" in here between the CER and the CET, that makes them equivalent designations, although different methods, equivalent certification. And we thought that would be only fair for the public as well as reporters in Tennessee.
And that's because we know how they enter in based on those designations, but it doesn't show up on their license. It's licensed court reporter, and so to maintain that parity, that's why that phrase was included. That there's a transcription, piece there if you're going to come in that CER pathway.
This is Judge Rambo. I have a question. How is this going to affect court reporters who already have their license but maybe do not have the certified electronic transcriber examination portion, but they've been doing this for years?
Those folks will be grandfathered in. This will just be effective once passed by through the process. Once Attorney General, Secretary of State all looks at this and it gets a clear bill of health across the board, then it'll just affect those incoming.
Right, Judge. This is Ashley Thomas. So this particular amendment applies to new applicants. So licensees that currently hold the license, and this part will not affect them because they already have a license. This is for incoming applicants.
Thank you.
I have a question, please. How will this coincide with TCA? Because TCA will not have that.
And that's the purpose of the rule, because the TCA has not been changed to reflect that. We added this designation. It does not feel to be over regulatory in any way. I think it actually helps helps the public, helps the industry, and so I don't think that there will be any conflict with that.
And the next part was the changing of preservation of shorthand notes to just untranscribed. And then again, that reflects the three different methods. Shorthand notes would seem to indicate manual shorthand or machine shorthand. And so since we recognized three different methods in Tennessee, that was somewhat ambiguous. And so just removing that to untranscribed notes just clears that up succinctly, I think.
Pets, did you have a question?
Sorry, I just, if we can back up just a second to that previous amendment to the application for, to make sure I understand it. So by adding the certified electronic transcriber examination portion to the, I guess, the American Association of Electronic Reporters and Transcribers certification, you're adding a practical component to that particular certification in order to bring it on par with the other classifications.
Summarized it correctly. Yes, sir.
Okay.
I also think the Second Amendment, I think it was reflective of maybe a complaint we had at the last meeting that kind of brought about that discussion, and that's what kind of prompted that particular change.
Is there any more questions from the board as to how we got here and what those changes do? Okay.
Well, this is Judge Rambo. I just want to thank the staff for following up on what we discussed at the last meeting and drafting it succinctly, consistent with what the board requested.
Thank you, Judge. Appreciate that. All right. Well, if there's no further questions, do we have a motion to accept that as written?
Make such a motion.
We have a motion from Mr. Mansfield to accept the amendments to these rules as articulated. Do we have a second? We have a second from Ms. Morgan for roll call vote. Ms. Branham?
Yes.
Ms. Neal?
Yes.
Ms. Morgan?
Yes.
Mr. Mansfield?
Yes.
Mr. Pettis? Yes. And then Judge Rambo.
Yes.
Thank you, sir. Thank you, board. That has passed. We can move on to the next item, which are board meeting dates. As you know, this board only has two. Now we can meet as often as we need to. We only reserve two because we have to get the room and get scheduled, and we want to make sure everyone's has plenty of advance notice of when those meetings are going to transpire and can prepare. But if it's the will of the board to meet in addition to the two that are scheduled, then we can always entertain that and do that. But we do have this room reserved for those two dates, and basically we just mirror that to each subsequent year. So you'll notice March and the September date. I'll give you a moment to check your calendars if you'd like to, or if if somebody could entertain a motion to accept that, or if we need to change that, if there's a conflict. This will be the time to discuss that before we post that to the website. Now, it's March 27th and September 25th, and that would be a Friday.
Make the motion, we accept those dates.
All right, thank you, sir. We've got a motion from Mr. Mansfield to accept the board meeting dates as written. Do we have a second?
Second.
We have a second from Mr. Pettis to accept those dates. For a roll call vote, Ms. Branham,
Yes.
Ms. Neal,
Yes.
Ms. Morgan,
Yes.
Mr. Mansfield,
Yes.
Mr. Pettis,
Yes.
and then Judge Rambo.
Yes.
Thank you, sir. Those have passed. Then we'll move on to the item of our agenda, where we have a couple folks that would like to appear before the board, TCRA, in regards to transcript preparation. If I may invite our first guest. Sure. We have Ms. Terrell here. We also have Ms. Sheila Wilson, and they're available to answer any questions that you have. I'll go ahead and just enter in what the discussion is about, and then, of course, if you have any questions that are particular, feel free to clarify where you feel like that needs to be done. All right. So it's in regards to transcript preparation on an inactive and expired license. Basically, Rule 455-101-02 -.05 inactive status currently states this. It's very short. It's a person not actively engaged in the practice of court reporting. That's key. So try to lock that in your mind. A person not actively engaged in the practice of court reporting. Okay, may place their license on inactive status by completing and submitting an application for inactive status. That's the current version of our rule. There was a former version of our rule that stated a person not actively engaged in the practice of court reporting may place their license on inactive status by completing and submitting an application. We got that. A person on an active status is not authorized to provide court reporting services in Tennessee except to certify transcripts of matters recorded prior to becoming inactive. So if they're in active status, they can't be actively engaged in the practice of court reporting. However, does the practice of court reporting, does that involve preparing transcripts? That's kind of did I properly confuse everybody, or did we sort of have an idea of where we're at? Basically, question one, is a reporter whose license has lapsed or been placed on inactive status allowed to transcribe proceedings taken while their license was active? So let's just deal with that one. I mean, is it the position of the board that if they're transcribing proceedings that were taken while their license was active, now that they're in active status, are they engaged in the practice of court reporting? We'll start with that one.
I would say they're engaged in the practice of editing the work that they did when they were licensed as a court reporter.
Our certificate says, as of the time we took the deposition. Our license number applied as of the time we took the deposition, not when we transcribed it.
As I understand it.
Speaking that mic.
I'm sorry. It's Brandon Pettis. As I understand the rule that you just read, that, essentially if you were working on a matter before you went into inactive status, then you're entitled to go ahead and produce that transcript for those matters. So there's sort of a temporal cutoff. So to the extent that these are transcripts that were for matters that the court reporter worked on before they went into inactive status, I think, that's within the purview of the rule.
I heartily agree with that. And I think that their certificate just should reflect the date their license was active.
The former version seems to comport with your position. But since it wasn't listed, we wanted to make sure to capture the position of the board in regards to that, their interpretation of that. Any other comments? Ms. Wilson?
I do have a question as to that particular rule 045501-02.05. The additional language, I believe Mr. Kupchak, is that right? I always mispronounce it, pardon me, that you and I communicated with about, and I believe Ms. Terrell as well, the last sentence, that a person on inactive status is not authorized to provide court reporting services in Tennessee except to certify transcripts of matters recorded prior to becoming inactive. I guess perhaps I'm not clear on when that was removed from the current rules, because you're obviously correct that what is posted online as the rules effective 2017. So when was this language, I guess, removed? Do you know?
No, there's no. I mean, there's. We can go and look at the timeline of that.
Uh-huh.
But the thing with rules is they go through quite a process. It starts with the board, and sometimes it can come from the public, and the board will adopt it. But along the way, through the Attorney General's office and Secretary of State's office, or any of the stakeholders, legislators, sometimes can have input in that process as well. Can just so. They can come out of the process with some edits, and so they'll take what the board requires. Now, if there's wholesale edits that completely change the nature of the rules, then typically we'll have a rulemaking hearing and then work that out, bring it back to the board, and then resubmit a package so we can go through that whole process again. But things don't always look exactly the same as when they're approved based on whatever those considerations. Without having the transcripts from those proceedings, and some of those don't necessarily take the form of a proceeding. I mean, they could just someone attorney may think it might not working in the industry might think there might be some confusion somewhere else, and so then they remove that to avoid that confusion. But we can very well, if it's the position of the board that they can transcribe stuff that things that they've worked on prior, then that's what we can do. We're not sort of hamstringed on that one because it's not articulated specifically. Not everything can be. There's a matter of administrative practice that just you just have to engage in. If there's a consensus in the industry that this is how you would treat a certain matter, then you're not required to have that articulated. Unless you run into problems like what we did with the complaints. So we realized that we needed a phrase untranscribed because there's things that are you have notes that go beyond shorthand. So to close any sort of confusion or loopholes there, we added that word. So we can do that.
And that kind of goes to why we brought the question to the board, because if there is confusion in the rule, we can bring it to the board for them to clarify as they just did, or if they see it necessary, we can go through a process to include that language. But the short answer to your question, we can look that up and get that information to you as to when that rule was amended.
This is Judge Rambo. I have a question. It relates to that, but a situation where, let's take an electronic court reporter that records and may have notes and then takes inactive status, but then decides they do not want to be bothered with doing the transcription. Is another court reporter allowed to come in and finish the transcription of a recording made by a different court reporter?
We would need some assistance from the board on that one. That would be more of an industry practice. So that does anyone have any input or comments based on that question?
One of our rules says that the reporter is responsible for their own production, which I think would bear.
But if a reporter's deceased, there has to be a work around it, because that's not serving the public if they don't get their transcript. Oh, okay.
Those are good questions. Is there anything in the industry that would account for? Does anyone know of a situation like that, or that would account for such a scenario?
Practices where a court reporter has been disabled, or other reporters have, quote, stepped in and transcribed or taken notes, and as long as there's enough there
right
to produce it,
right,
it has been done.
So, Ms. Morgan, if I'm understanding you, it's your opinion that it can be done by another licensed court reporter, should there be circumstances where the original person who was at the proceeding is unable to complete the transcription.
It'd be a matter of course, but it should be an exception made for certain circumstances.
I would think so, and I would add that the transcription should reflect in some form or fashion, when it's certified, that a different court reporter did a portion, whatever portion, and they completed it or just did the transcription part based on the recordings and notes of the other court reporter. I think the parties need to be aware that there was a handoff that occurred.
But what we do when we get audio recordings that attorneys want transcribed, we put in our certificate having not been personally present. You
Okay.
certify this is accurate and complete, however, having not been personally present.
But there'd have to be, mitigating circumstances to your point, Mr. Mansfield. It's not just somebody refuses, but if they were incapacitated for some reason or unavailable due to being deceased, then, there has to be a pathway to accommodate and to serve the public. Okay.
I think, to Judge Rambo's point, I think it strikes the proper balance between, protecting the integrity of the process, the integrity of the court reporter who picks up from the one who's experiencing some incapacity, and also protecting the public. So it's a good suggestion.
Questions?
Yes. As to that, would the TDCR consider on your website under perhaps your FAQ or under your suggested, there's suggested reporter certificates for transcribing audios and so forth, if perhaps we could have something along those lines as a suggestion on how to word a transcript, how to word a reporter certificate, that might be helpful. And in line, that may address as well question number 1, and they're kind of one and the same, but somewhat similar. And my other question is, if there are other rules that are different than what are posted on the website, if TDCI is working off different rules, like the additional language you quoted on 0205, that's not what's on the website. So if we could kind of all be working on the same playbook, that would be helpful.
It's the website should link you if you go to the rules and laws. If you on that one column, when you click on rules, it takes you directly to the Secretary of State site, which has the updated there. We'll discuss it. That's an administrative matter. We can definitely work that out. If there's inconsistency, we'll talk about that afterwards. But it is available, and it links us straight to the Secretary of State site. That's where I've gotten our version here.
Okay, so the link that's on TDCI, so that I'm following, the link that's on TDCI, you click under court reporters, and it goes under TBCR, and then to the left of that module, you can click under rules and regs and laws. And if you click currently on rules and regs, what is currently on there is what I just printed out that does not have the language that you quoted from. And you're saying there may be other rules? Am I?
No, there's not. No, that's the right link. If you have an older version, what I would
I just printed it yesterday.
I would clear your cache. It's probably pathing you back to the former rules. My IT webmaster gets me all the time for this. If you don't clear your cache, your internet options, it'll path you back to the old stuff. So try that first, and then see if it doesn't take you to the new current version.
Can we maybe check that before we leave
Sure.
today? That'd be great. All right.
Were those all the questions?
One further question, and you may have already addressed it, and we may have addressed it last session, and if so, I apologize. But I did make a request of TDCI for a copy of the current application for licensees or potential licensees. I couldn't pull that from the website only because I think you have to go through a renewal, and it won't let you renew just yet because it's not time. So if we could remove from that, I assume it's on the application, the wording digital and also other. And the reason I say that is when you're looking at the list of LCRs right now, it says under method, it says digital and also other. And so when you're asking for questions on how many licensees are steno, or how many are digital. Some of those say under method, they'll say digital slash electronic slash other. There shouldn't be an other. And the word digital is not addressed in our law, so I would just ask that those things not be on the application. It only needs to be electronic, pen, steno, and voice. So it makes it hard, if I ask again for numbers of certain types of licensees, I have to also ask for other. Is that making sense?
It does.
Just,
The only thing I think of is perhaps other states. That's probably why that was adopted and put on there. But
Okay.
if it's creating a problem, then that's easily removed.
Okay.
Mhm.
Great. I believe Ms. Terrell has one question, so let me see if I can get her to post it. If not, she can tell me what she wants next.
But I'm sorry, I'm Lynn Terrell. My original question was addressed two parts. You have to fill out a form and request to be put on inactive status. Whether if your license is lapsed, if you're considered inactive. There's a difference in the cost. There's a $500 fee to bring your license from an inactive status to an active status. And if you simply let your license I'm sorry. That, so my question is inactive treated the lapsed or non-renewed as far as transcript production?
If that's specifically for inactive, if it's lapsed, it's expired. They don't have a license.
And they cannot transcribe then a proceeding after that. Is that
They would not be able to engage in court reporting proceedings or work. So whatever would be deemed court reporter work, we're kind of back at that point.
That's my question, because we have reporters who are retiring, and they need to know if it's okay for them to transcribe and what they and not apply for this inactive status.
And that would be an interpretation from the board. It sounds like they're not engaged in, from what I understand, actively engaged in the practice of court reporting if they're basically transcribing their own notes of when they were active. And I imagine if we're doing that with inactive, would we also apply that to those that have just expired? Is that the position of the board, or comments would be welcome?
I think it would be the same thing, lapsed or inactive. Either right, they're inactive and they don't have a current license, but they still could transcribe what they had taken down when they were active.
In order to be placed in inactive status, you have to actively fill out a form and request to be placed. That's the reason I'm asking this question, that they're not going to be treated any differently.
No. From what I'm understanding from the board, they can transcribe their own notes. Now, there's different reasons why some folks would go inactive or go expired. For example, if someone realizes they have retired, they're not coming back, then they would allow themselves to expire. Someone that goes on inactive status is sort of leaving their foot in the door. They're saying that I don't want to have to reapply. I'm pressing pause. I still have to do the CE that's required when I come back. So that's not a loophole. You can't escape the CE. You have to come, if you come back to active status, you owe us whatever CE that for the duration that you're out. But that's the difference between the two. So it would be the professional decision for the court reporter to decide. Am I retiring, never to come back? Because if they do and they expire, they can still transcribe, from what I'm understanding from the board, the stuff that they've worked on. However, they would be subject, if they came back, they would be subject to, as if they were initial court reporter. That means a current test, all that.
I do understand that it depends on the length of time that that license is expired. There's no fee on the schedule that I was given that's as much as $500.
So is
That's my question.
yeah, the equity of the fee is cumbersome, is what you're saying.
Exactly.
Yeah, okay.
Exactly. We're all.
That would have to be decided by rule.
I also don't. I was curious as to where the $500 fee came from.
When you say fee schedule, to what are you referring? If I can ask.
Well, may not be accurate or up to date now since I pulled it from the website, but it is reference, I believe, in answer to your question, Ms. Thomas, Rule 0455-01-02-04, where it outlines the fee structure there, and it's actually under entitled fees. And there is one for a reinstatement, clearly, and that would seem to, a layperson like me, that would fit an inactive status, because it actually talks about inactive a little bit later, and restoration, which is
and the amount of the fee that you're looking at.
We're wondering where the $500 fee is coming from, because it only says
That rule was amended. It is now $350. That was changed when the Tennessee Board of Court Reporting was brought over to Commerce and Insurance. That was one of the first changes that they made.
Okay, I think Ms. Terrell has had questions from LCRs that are TCRA members that are under the understanding that it is $500, and it seems like they may have gotten that information incorrectly. It sounds from TDCI that the initiation on the reinstatement fee for an inactive status was $500, and that's kind of where we went down this rabbit trail. Where is what's cheaper? What's going to be in the best interest?
Excuse me. It is on the application to.
That online.
Jamie sent it to me.
Okay. Yeah, and sometimes it can be I have to take a look at it, but typically it can be depending on what you're trying to do. Like, for example, auctioneers, they have a license fee, an application fee, and then a modifier fee. So that they're all on the schedule, but it doesn't say you add those up by items, and then you have a total. So you could have potentially an application fee, a reinstatement fee, the license fee. So those could total up to. I'll have to look at it, that transaction, and I can get back with let you know for sure.
The inactive fee is more expensive.
And plus the fact that if I went, if I made my license inactive tomorrow, and next week I had to pay $500 to get my license reinstated. Or if I just let it expire, I've got more time with a lower fee if that should happen.
Okay, but if you let it expire, won't you have to recertify? You'll have to pay all the expenses of RPR and all this other.
My understanding that that's what we're looking at, is the cost and the feasibility of, and that's the reason for this question of whether we have to actually take inactive status in order to be able to do our transcripts, or whether we can just still be able to transcribe.
What I'm hearing, you can expire.
Exactly. That's the reason I asked the question, though.
Great, good question. Thank you. But that's where we landed on that one then.
So all you have to do if you expire to reinstate is pay $20?
It's $20 a month.
That's in addition to your renewal fee. It's a $20 a month late fee in addition to the renewal fee. Opposed to putting it inactive, and then you're charged $500.
And just for clarification of the record, there may just be a reflection of an old application that needs to be updated where it says 500, because by rule it says 350, so it may just need to be a change to the application, the language on the application. Absolutely, I understand that, and that's why I said it may just needs to be updated.
Was that the paper app that you received, or is a link? I'll get back to it with you on this fee schedule and break that down for you. Then I put it down as my action item, so you'll hear from me. Thank you.
I have a question, trying to wrap my head around this. So we have to hold our notes and our records for years. So hypothetically, if someone came back 4 years later and said, I want this transcribed, and you've been inactive or retired for 4 or 5 years, so then you have to pay the fee to be active to transcribe that one job? Or you just do it and it goes back?
According to the earlier conversation of the board, transcribing from something that you did while you were active is not the practice of court reporting. Unless the board changes its opinion of that, then something that happened while you were an active licensee, you can transcribe.
So your software support's up to date.
I just do have one more question before we leave this. I'm sorry, and that is a recommendation for what to put on the certificates. We're asked that. We're being asked for recommendation for what to put on their certificate if they're transcribed after their license is expired. I was just wondering if the board could get a
Talking about just a statement on those transcripts is.
My opinion is that it would just take a simple statement like proceedings on date of, which shows the date that you took it and that you're. I don't feel like I can tell court reporters what to do. I would like to have the board, if you would, just example, something to go by.
I think we could submit some documentation to that effect and see whatever seems real. But guideline, not a mandate.
Right, exactly.
And that just requires that can be a little difficult to do, just because we try to stay within the scope of the law and not like industry practices. And so that's we have with other boards. They try to provide some sort of industry examples, best practices, but even there you have to be really careful, because then you could start getting into sort of regulatory type functions, by that practice. So, we'll have to, look at some of those statements, run those through legal, and go from there. So I don't know that we'll get exactly what they're wanting, but we can entertain the idea and look into it for sure.
And I think to Glenn's point, to give a uniform statement without a rule or law to support that, kind of leaves the impression that if this person does not use this statement, they are in violation of something, but we don't have any rule or law to tie it to. So I think what Glenn is saying as far as suggested language may be something that the board can provide, but to say that this is the language that needs to be on those transcripts, I think would kind of run afoul of the rules and laws.
As a matter of practice, the board has decided that they're not engaged in the business of or practically engaged in court reporting. So, if they're transcribing those notes, and if someone's doing that for someone that was incapacitated, it does appear to me that best practice would indicate that they do that, as Judge Rambo suggested, and in practice, the other court reporters have said that they've seen that. So, but to sort of, articulate like what Ms. Thomas said, a specific phrase that must be used, that may be confusing to folks. And so that'll be something that we'll have to sort of sparse out and work through and figure out. But we'll look into it, sure. Mm-hmm.
My certificate, I always put words to the effect that I personally reported that case. That's on every certificate that I put out. And so that kind of takes care of it. And it was reported on such and such date. Well, I was an active reporter when I personally did that. But if I have retired or gone inactive for any reason, my expiration date's going to reflect that on my expiration date. But still, that was to show that it was within the time frame that I was a licensed reporter when I reported it, and when it was transcribed. Because, as you all know, you can retire and somebody can ask for something 4 or 5 years ago, as Stephanie said, and still we were active at the time, and we just have to go back and produce the transcript. It may have been all ready to go anyway, but it wasn't ordered. It just printed.
That's what I had in mind. I know we have a certificate.
I know many times.
That would solve our problem that date when it was taken, I think.
Many times I've had cases where I've sent out transcripts where it shows that my license has expired because the original person that wanted the transcript, well, maybe somebody wants a copy 3 years down the road. Well, I'm in a new cycle now. And so it shows when I took it, full compliance, but it also shows I'm expired, which I'm not, but that's what it shows because I can't go in and change it because I think it's the same situation.
Worst case scenario, a court reporter retires. 10 years later, the transcript, and that happens. And I don't want to. Say the court reporter, I'm too old. I don't have any equipment anymore. Then is the reporter required to produce that transcript or?
Actually, I had a second question that I don't think you read. Let me read it so that I'm getting my wording wrong. If a reporter who is or was licensed is unavailable or incapacitated and therefore unable to provide a transcript of a proceeding that he or she reported while their license was valid, is allowed to transcribe the proceeding, and what should the certificate reflect? Recordings.
Certificate's fine. Yes, that's fine. I'm just saying, well.
But I don't know.
The original one.
If it's not their work, then what would be their basis or qualifications to transcribe it? Because we're assuming that the person that's transcribing it was licensed. That was our presupposition for saying that, yeah, they can go back and transcribe anything that they were previously licensed to do. So, it'd have to be, I would imagine, a licensed court reporter, and help me out if someone has any comments on that. But because otherwise it could be anybody. Like I could transcribe something and I haven't had no training whatsoever. That's chaos. So that would have to be a licensed court reporter.
It would have to be a licensed court reporter who would pick up the slack and take care of this situation because no one else could do it. Wouldn't be authorized to.
That's the thing with the legislation when they pass a code or a TCA, and I'm don't want to step on legal. If I get a foul, please put me back in line. When they pass a law, a legislator who's not a court reporter, it'd be like me if you elected me to office. I might have constituents who are court reporters to say this is how we want things done, and that would be the benefit. And that's industry best practice. That law would get passed. But it's up to the board to from there to write rules, and then the rules basically are the interpretation of that law. Now, not everything has to be articulated, because then you get in the point. There is some you can't. That's why we have a appear before the board section. If we get into ambiguity and we have enough of that, then we'll from either the legal report or from applications, we'll make that into a rule. But there has to be some discretionary powers within the board to make those decisions based on the best interest of the public. We're not articulated specifically either in statute or in rule. So for us to write a rule or a statute based on every scenario, that's why it's the exception to the rule. It wouldn't be the exception if it happened all the time. It'd be the rule. So we can't possibly account for every situation that exists. But if we
Additionally, I would just offer that a person that is undertaken to transcribe something that they have not recorded would be akin to unlicensed practice. And so for that, I would cite to the unlicensed practice statute of 20-9-603 of TCA.
I'm sorry, did you say a person?
In response specifically to your second question about a reporter who becomes incapacitated and then someone else takes up the job of transcribing that work. If they do that without a license, I would suggest that is unlicensed activity, and that would be an unlicensed practice of court reporting.
That was my question. Who is allowed to transcribe in that situation?
-9-603. 20-9-603.
That goes back, though, to the fact that licensed court reporters use Scopus, typists, use all forms of ways to get that transcribed. And so then if you've got a court reporter who's out of business, they can't have a Scopist.
It'd have to be industry standard. From what you're describing. Yes, ma'am.
Ms. Morgan, it kind of seems like, I hear what you're saying. It kind of seems like that would be okay if say you retire tomorrow, 5 years down the line, you had a request for a transcript. If you didn't want to do it, couldn't do it, didn't have whatever. But say you used a Scopus during the time that you were reporting, and that Scopus could read your notes and so forth. I don't see the harm in having that Scopus or any Scopus transcribe it, but a licensee, a current licensee, would have to sign off on that, attesting to the accuracy. And it sounds to me like that also goes back to what Judge Rambo said initially, that the parties and the council need to be informed of that this was transcribed by so-and-so, but it would have to be, and like Ms. Thomas was saying, otherwise, yeah, if just the Scopus did it, that would be an unauthorized practice of court reporting.
And
so
I think
you're
get back into that.
Yeah,
we
yeah.
were into that, about producing your own and, the strict interpretation of things.
Right. But it sounds like it's okay.
Have another licensed court reporter, they would just have to take it over and say,
Exactly.
here it is.
Yeah, I mean,
I'll bind it, I'll certify
I
it.
attest to the accuracy to the best of my ability, given the circumstances that I'm under, type of thing. That's sort of, hopefully that's kind of making sense. And then
It is. It sounds like the cure that you're proposing, and I agree with, is if the reporter was active at the time and they're personally transcribed, that's okay.
Sure.
If they don't personally transcribe, it has to be a current licensee.
yes.
And I think that solves the whole situation.
Yeah. And if the licensee is retired and the then retiree wants to give a second look at it, at the final product, I think there's nothing wrong with that. Hey, if he or she is dead, you got to serve the public. So otherwise, yes, I mean, we all do it just to the best of our ability. And like Judge Rambo said, you let everybody know ahead of time and give. I don't really see a problem with that.
Rule of reason, as they say.
Yeah, I don't really see a problem with that.
And this may sound like a lot of discussion over one little maybe thing, but court reporters are aging out, and there are going to be a lot of retired court reporters.
It is
one
important.
day.
You're right.
Yeah.
It is important.
It is important.
This is Judge Rambo. My suspicions, and I don't know this, is there might be 2 or 3 handful of court reporters, each with their own license in the same business or organization together, and one is going and recording the hearings, trials, and then a different court reporter is transcribing them.
Judge Rambo, this is Sheila Wilson. I'm wondering if you're talking about the distinction between a CER or a CET.
Yes.
And I believe you're saying that yes, that was what we, I believe, discussed last week, is the the CER records only, but under their certification, not their license, but under their certification by their national association, they are only certified to record.
I'm talking about those who can record and transcribe, but essentially you'll have one who will go to the courtroom and either likes to do that part, and then the other one who could do both parts transcribes it for the other court reporter. They're in the same office.
Would that statement on the transcription, would that satisfy that then, if they said I did not personally, or what we were discussing earlier?
Probably would, but I suspect that may happen quite often on electronic recording. You'll have one person who's in the courtroom doing the recording and someone else who would rather just stay at home and do transcription.
Judge, are these mainly criminal court reporters? Title 40? Civil?
Yeah.
Ooh, that's problematic.
Judge, this is Sheila Wilson again. I'm a little, I hear what you're saying, I do, but without the new rules, a CER has the ability currently in the state of Tennessee to submit their application to TBCR and become licensed. So I'm kind of curious why even you can almost look at the CET person, the typist, we'll call it just for ease of conversation, the same as a scopist. But the licensee, which would be the CER, if they're licensed in Tennessee, would still be the final say-so on the accuracy of that record. Is that making sense?
Yeah, but as a practical matter, if someone else is transcribing your recording, to me, it'd be highly inefficient for you to go back and reread it and listen to the recording and read the transcript for accuracy. Maybe they do that.
Judge, that this is Maryland. That's what we do. Mm-hmm. That's okay. And that's why we're requiring that extra certification. The person taking the deposition by electronic or machine or by hand, they need to be responsible to sign off on that after it comes back from a scopist or typist or whatever.
Shifting topics just a little bit, a lot of references have been made to retirements. We need, or somebody needs to look at more training or how we can recruit the next generation of court reporters, because I've heard complaints from my criminal court judges about having to cancel hearings or trials because they can't get a court reporter. There's just so many to go around. Of course, it's a little bit different with criminal, but I've heard court reporters tell me that the youngest one in the area is in their 50s and there's no more court reporters coming along. And we have all these trade schools, community colleges. I don't know if we could go to a trades type apprenticeship program. I don't know, but something needs to be done to ensure the pipeline of future court reporters.
This is a problem, and a lot of the problem is this. Some of the surrounding states offer positions called official court reporters. Tennessee, some years ago, has decided not to offer those positions anymore, so there are no more salaried court reporters coming online. So basically, the state of Tennessee, and in essence, has said this is no longer a viable career for people who want to be employees with the state of Tennessee. So I personally know a lot of people who have moved to other states to take officialship positions or gone to the federal government to take federal official positions. And so if this could be addressed, I think it would make a huge impact in the future. It might take a few years for it to catch up. But if there were salaried positions offered to court reporters, just like there are other individuals in the legal system, people would be wanting those positions. I really do believe so.
So they changed that, 5 or 10 years ago, where they eliminated the positions and went to contract?
And you've seen what's happened since then.
The official court reporter position in Tennessee used to be the job to have. That was what you aspired to have because you had the insurance, you had benefits, but now it's hard for them to even find. That's why they're going to audio, because they can't find a court reporter who is very skilled and knows what they're doing to go take those jobs.
I've made this analogy before, and it's not really a good analogy, but it's still an analogy nonetheless. If the state of Tennessee decided that we're no longer going to hire school teachers, we're just going to have substitutes come in and teach from now on, what would happen in 5 or 10 years with people going to college to become teachers? It would be a great decline in people seeking to become teachers in this state. Same with court reporters. And they're going to other states for those officialships. That's why one reason our numbers have diminished, because the people who want official positions have moved.
Judge Rambo, Sheila Wilson again, and I promise this will be my last time I'll shut up. But going back to your question, I think we're all in agreement that yes, this is an issue that statewide and professionally, nationwide, that we have to address. But, and you may or may not recall, but just this past, I guess it became effective July the 1st, several court reporters within the state of Tennessee supported and lobbied hard, very hard, successfully for a pay increase for the criminal court reporters. And that was done, respectfully, sir, in my opinion, on basically for two reasons. Yes, to provide an increase, a pay increase for those few people that are still doing criminal court, but also to encourage freelancers like the rest of us. We don't want to go to state court. I don't want to go to criminal court because they're not going to pay me enough. Why would I do that? So that was the objective, was to bring the scale so that it's not exactly equal to freelance, but at least it would be in the ballpark so that others of us would be able to come in, be willing to come in and cover criminal courts in particular. And on a nationwide level, our National Court Reporters Association, as well as TCRA, on a statewide level, we have a program called the A to Z, and it basically is an introductory. It's an 8-week class. It's open, free to the public. We do it. We're doing it way often in Tennessee. So, if anybody in your church, your next door neighbor, people at the cash register, at the grocery store, we're trying to encourage them and spark an interest in court reporting so they get a little taste of it. Again, it doesn't cost them anything. They can attend via Zoom. We teach them the alphabet, and the idea is, because there's not, there's nothing, doesn't cost them anything, and we help them find a school. So we're hoping that we can kind of shift this tide in the future. But agreed, it is going to take a while, but we recognize that, yeah, we're getting older and it's getting harder. But those are some things that we are trying to do to address your concerns in particular, sir.
Well, thank you. And that may be type of information that needs to be disseminated out to high school guidance counselors across the state and some of the tech and community colleges.
Yes, sir. And in fact, the Tennessee Court Reporters Association just participated for our second year in the school guidance counselors at their convention. And as I understand, we are getting outreach from those associations for us to come in and speak to their potential high schoolers to hopefully let them know that the opportunities that are available. And so yes, we are doing that. Yes, sir.
That's great. Thank you.
There is one other program going on. It's Simply Steno, and I'm involved in that, trying to get that started, where we're trying to recruit spouses of military spouses and retired military as a second career to go into. So, you know, that would be the perfect career for a military spouse. They could work anywhere. So there are a lot of efforts going on.
That report, I appreciate that. Unless there's any other comments, I think we're ready for the legal section of our agenda. I don't think we have any other legislative items except for the legal report.
Okay, Dennis Gregory. We only have the one report or the one complaint to put on the report for the board to consider. Not sure that it's necessary to be the whole summary to be read into the record, but summary is there along with the recommendation. Complaint number 2019-02-2351.
Personally, I would prefer, instead of it being a letter of warning, just a notification letter. Now, you need to keep your completed certificates, because before, the understanding of the law was if you could show proof of passage and you could get a certificate from NCRA that just listed it and had all the CEUs listed, that was sufficient. It's only since the Department of Commerce and Insurance has taken over that now you're required to keep the actual certificate themselves. And so that's just more of an information that this is what's required henceforth going forward, that you need to keep your completion certificate.
More like a letter of instruction, maybe.
Absolutely.
Curious how many random audits are being done.
It's just random.
I know.
All right, what was that last part? You said the
I was
audits?
just curious if there are quite a few random audits being done.
We do a 10% audit. The last audit we did is obviously if we were licensing throughout the year, we would just do quarterly audits, but we do a 10% audit after the biennial renewal period.
I think that's good for reporters to know, to keep your records.
2 renewal cycles. No, we're not quite like the IRS. We don't ask for 7 years, but we do ask for 4. So, okay. We'll need a vote then on the or a motion rather on this. The recommendation, of course, was a letter of warning. Is there any further comments or?
I make a motion we just send an instructional letter instead of a letter of a warning.
Chancellor Rambo seconding the motion or amendment.
All right, we have a motion to amend that to a letter of instruction by Mr. Mansfield, and then we have a second by Judge Rambo. Any further discussion? Just for clarification for the new members, a letter of instruction is not discipline. It's just that, a letter of instruction. A letter of warning is discipline. So that's the only two. That's the difference. They're still getting a letter, but one shows up as discipline, one doesn't. It's kind of like, you're speeding in some zone and you're 10, 15 over, that's their warning. You're saying, hey, slow down. Next one, there'll be a warning or we'll be disciplined. That's the idea. All right. Any further comments, discussion? Okay. Well, then we'll do a roll call vote then. We have a motion by Mr. Mansfield to amend that to a letter of instruction. Of course, we have the second by Judge Rambo. Stephanie Branham?
Yes.
Corinne Neal?
Yes.
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 Brandon Pettis?
Yes.
Judge Rambo?
Yes.
All right. That's been so amended then. That's it. We don't have anything to be represented. This moves us to our new business. This is an opportunity to anything that wasn't on the agenda or that hasn't been previously discussed. We can introduce that here as a topic of discussion. Is there anything that the board would like to introduce?
I would encourage people to sign up for the Tennessee Registry to cover criminal courts. Hopefully one day they'll open up officialships again, but until then, if we could have many reporters sign up to help in the criminal courts, that would alleviate the burden on some who are trying to do it too much and spread it around so that they would have coverage. And there's frankly a lot of cancellations in those courts. Sometimes people decide to take a plea at the last minute. So if we could do that, I just encourage everybody to do that and have a large list to draw from so that we can have coverage in the criminal courts without any issues.
That announcement, then I imagine the court reporters know where to go then to enter in that registry.
You can just go to the AOC and get in touch with Connie Turner, who's the paralegal in charge of court reporting services.
One question for legal maybe, or something to look into. We're having a lot of trouble, freelance reporters. When a witness requests to read and sign a deposition, the attorney just has it because it's a read and sign. They're not paying for a copy. They don't want to pay for a copy. And they say we're required to give it to them because it's a read and sign. Our law, our code says we have to make it available. However, the problem really comes in when we have out-of-state cases, other jurisdictions. We don't know what to do. Are we required to hand over a free copy so they can, read and sign it? And court reporters need guidance on that.
I can tell you my practice if you'd like to hear it.
And I do.
I make an electronic email, a PDF copy that's not printable. Now, the PDF signature page and write sheet can be printed, but the rest of the body of the transcript, they can read on screen, they can make whatever notes they want to, but they can't print it up, and they don't get a copy.
But what about if you have a New Jersey law or a California lawyer who comes in to take an expert at Vanderbilt?
Send it to their email address and let them get their witness to sign it. That's the best way. That's the only thing I can tell you.
Yeah. I don't know. I don't know if there's any way to require that either they purchase a copy or the taking attorney furnish them a copy.
I will. I'll look into that and try to
Thank
get an
you.
answer back to the board.
Thank you.
Could have them come to your office.
Well, that's what. Yeah, they don't want to fly from
Right.
California.
Because I thought too, isn't there? I thought there was some code that it's considered work product
I don't think so.
and can't be.
I think
disseminated.
it's the work product of the attorneys. It's not ours.
I tell you what, I experience a lot. We have transcripts that get filed in the court file, and then either the pro se party or the other attorney comes in and wants to make a photocopy of that instead of getting one from the court reporter.
That happens a lot.
Yes.
That's running a lot of us out of business. Yeah.
Yeah, these are things that have had a detrimental impact upon the profession of court reporting.
And I think that is something that should be looked at as far as a Tennessee Code annotated change to where you can look at it in the file, but the court reporter does not have, the court clerk does not have to provide the copy. They
That
have
would
to
be
go
good.
back and buy it
That would
from
be
the court.
awesome.
That would be good. I wish, as long as you're looking at the code, that you would also pattern the code after the federal rules where read and sign is not required unless it's specifically asked for. In other words, signature is waived unless otherwise stated.
Well, there's we all have representatives in our district that can get that moving for us. So that would be outside of our scope, but nonetheless, those are some good points though to consider, and something I would definitely bring up and put that in front of folks that make those determinations and would make those calls. That'd be great.
Another incentive for someone to come into the profession. It's something that's on time.
Unless there's anything else, I think we're ready for the next portion, which is our adjournment. So unless we have any more comments, we'll accept a motion to adjourn. Do we have such a motion? We have a motion from Ms. Morgan. Do we have a second?
Second.
We have a second from Mr. Mansfield. Ms. Branham?
Yes.
Ms. Neal?
Yes.
Ms. Morgan?
Yes.
Mr. Mansfield?
Yes.
Mr. Pettis?
Yes.
Judge Rambo?
Yes.
Thank you, Judge, for your time. I appreciate you calling in today.
Thank you all for accommodating me.
Yes, sir. You have a good day.
Good.
I have a question.
Smiley face.
Yeah. Oh, hey. Well, I just went to the dermatologist yesterday.
Oh.
Is it terrible?
Do I need to come over there?
If you don't mind.
Are you feeling okay?